This is Tom Fox. I'm the Compliance Evangelist. I'd like to welcome you to episode 299 of the FCPA Compliance Report. Today I have with me Philip Urofsky. Philip is a partner at Sherman & Sterling in New York, and he leads a team that puts together Sherman & Sterling's annual FCPA Digest, one of the top annual compendiums about all things FCPA that is put out there in the marketplace. In this episode, we talk about the 2017 FCPA Digest and some of the key points that Philip and his team discussed in it. We include a discussion of the expansive regulatory view of anything of value as demonstrated by the Qualcomm, JP Morgan, and VimpelCom case. We take a look at a jurisdictional issue regarding the Magyar Telecom case and some of its executives. We talk about the FCPA pilot program, and Philip gives his thoughts on what has been successful and what is lacking in the pilot program. And we conclude with taking a look at the increased globalization of international anti-corruption enforcement. The episode comes in at just over 30 minutes. This is Tom Fox. I'd like to thank you very much for listening to this episode of the FCPA Compliance Report. Hello, everyone. This is Tom Fox. I'd like to welcome you to another episode of the FCPA Compliance Report. Today, you are in for a real treat because I have with me Philip Urofsky. Philip is a partner at Sherman & Sterling, and Sherman & Sterling has recently issued its stunning annual FCPA compendium. I think I'm right in saying it is the granddaddy of all, Philip. I don't think anyone else did it before you guys. You've certainly been doing it since I've been in this field for the last 10 years. And I wanted to thank you for putting out this incredible piece of information for the compliance community. But I'm really thrilled to have you on the podcast to visit about some of the things that you and your colleagues have observed over the past year.
Well, thank you. Happy to be here.
So I think we can probably both agree it was a stunning year in FCPA enforcement. So I wanted to just get right into it by asking, were there any trends or highlights that stood out to you?
Well, it was an interesting year. It started out a little bit slow. It picked up a lot toward the end. And there were some interesting cases. Some of them weren't so interesting. They were run-of-the-mill. And, the FCPA, I think, is mature enough at this point that you will have run-of-the-mill cases where there isn't that much to be said. But some of these cases do raise interesting issues in terms of the department and the SEC's enforcement policies and their interpretation of some elements of the statute. I think there are certain trends that we've identified in this year that reflect perhaps a diverging predilection among the enforcement authorities at the DOJ and the SEC. But it's also possible if Mr. Clayton is confirmed, if President-elect Trump's nominee for the SEC chair is confirmed, that there may be a convergence, because there certainly seems to be, in their published work, some degree of agreement between the chief of the fraud section, Andrew Weissman, and the nominee for the SEC chair, Jay Clayton.
Well, I would certainly agree with that observation, but I was wondering if we might turn to some of the cases, really starting with one early in the year in Qualcomm and maybe marrying that or bookending it with JP Morgan, which seemed to be a reflection of the regulators' expansion of views as to what the term anything of value might be. Is that something that you and your team really picked up on or thought was a new or different interpretation by the regulators?
Well, this is an area that has disturbed me for many years. Certainly Qualcomm and JP Morgan are current examples. I can say that when I was in the department myself years ago, we had debates as to what exactly it meant to say that you needed to convey a thing of value to a foreign official. The statute says money or anything of value. I've always interpreted that, and I believe it was intended to be interpreted as a tangible thing of value, not something that simply makes the government official feel good about you. The FCPA is a quid pro quo bribery statute. It's not an influence peddling statute, and it's not a lobbying statute. or for that matter, it doesn't cover all unsavory conduct. And what you see in Qualcomm and JP Morgan was alleged efforts by the companies to influence government officials who were in a position to award business by providing gifts or entertainment or jobs to the government officials' relatives. And there's no allegation in these cases that these gifts or entertainment or the jobs went into, benefited the government official in any way other than maybe he felt better about it and about the company, and therefore maybe he awarded or would award business. The Qualcomm case is perhaps, it's an interesting development in the sense that it goes beyond what previous cases on gifts and entertainment had covered. In those cases where a relative was involved, the relative was either an intermediary or accompanied the government official, for instance, on a trip, going all the way back to Metcalf and Eddy. You have the government official traveling with his entourage, including his wife and I believe some children. In the Giffen case, you have the gift of snowmobiles and fur coats to the president and his wife of Kazakhstan. Here, you have there's no allegation of the involvement of the government official, which begs the question, or raises the question rather, of how did that government official receive a thing of value when his relatives may have been profiting from his position, but is that an FCPA or leveraging his position? Is that an FCPA violation? Then you move to JP Morgan, where you have a effort to allegedly to influence government officials by hiring their children or relatives as interns. And this is perhaps a step from previous cases which alleged no-show jobs, where the mayor's brother is hired as a security to provide security for a oil camp and doesn't show up and never shows up, and no one expected him to show up. But even in those cases, there was an allegation that somehow the mayor benefited from this. Here, there is not that allegation. There is an allegation that the hiring was intended and was designed to influence the official, but not how or where or in what way the official benefited from that hiring. Now, they did in JP Morgan allege that these were unqualified hires, that these were people who, they may have shown up, but they weren't qualified. They would not have been hired had it not been for their parents or their relatives. And that may be a little bit of a step toward implying a benefit in that if they're not qualified to be employed, the government official might have had to support them. But they don't say that. You have to sort of guess at how the official might have benefited from the employment. And it raises a separate question: is what if they were qualified? What if they were, they had gone to the right school, they had the right skills, yet they were, there were other candidates who were equally qualified, but you picked this one because of their parent. It happens all the time in the United States, I'm sure. Why is it a violation of the FCPA if it happens outside the United States? So these are to me, as I talk to my clients about compliance, very difficult cases, because you look at this and you say, well, how can you possibly get it right? Is a person disqualified from being employed simply because their parent does business or is in a position to award business? Isn't the answer similar to in the United States, that you should try to ensure recusal or conflict of interest laws, but you can't necessarily police the parent? And if there's not a quid pro quo, if there's not an agreement, if there's not a conveyance of benefit, how did you violate the FCPA? These are the questions that I think these cases raise. And VimpelCom is another case this year that also raises, to some extent, the same question, because in VimpelCom there's clear allegations of traditional bribery of conveying lots and lots of money to a government official. But one of the allegations is also that the company gave a substantial amount of money to a charity that was sponsored by that government official. But there's no allegation that that charity was not a legitimate charity. And there's no allegation that any of that money that went to the charity, as opposed to some of the other funds, went into the government official's pocket. And in that case, it's different than some of the earlier charity cases like Sharing Plow or Eli Lilly, where the allegation was that the government official who either lived in the castle that was the subject of the charity or in somehow otherwise benefited from the contribution to a charity. Here, in the Vimpelcom case, it's simply a charitable donation intended to influence the government official, but there's no evidence again here, or no allegation there, that the government official received any bit of that money.
So previously, I'd always advised clients, or at least certainly taken the position that if a potential candidate was qualified for a position at your company, they went through the standard hiring process, they met all other qualifications, as you suggested, that it was acceptable to hire that person if they didn't work, if they were basically Chinese walled from their relative or their parent, any work that they might send the employer. Do you think that interpretation may be in jeopardy now after the Qualcomm and JP Morgan cases?
Yes, and it shouldn't be. I mean, I think your advice to your clients was pretty much aligned with the advice of most of us to our clients. But in this case, if your clients followed your advice there, or followed my advice in similar cases, you still have this situation where, okay, I've hired the daughter of the minister who went to Wharton, has an MBA, has already worked in the industry, and wants to work for me. And so I say, well, okay, good. But, your father is in a position to award, certain types of business, so you cannot work in that part. We're going to move you to another country, or we're going to, employ you in an area of our business that is not under your father's, area. And that would, and therefore, we've minimized the intersection and the ability of your father to award you business, basically. But now there are, if you look at JP Morgan and these cases, then you get a situation where just hiring her is enough. Somehow is enough to violate the FCPA, because you've hired someone and that person is in a position to award business and may award you business. And in some cases, this is where the curse of the email comes in, because you may have hired her knowing who her father is, and you may have acknowledged that in your hiring considerations, that this is, among our candidates, here's a person who is networked into the foreign government because of her background and her relatives and her classmates, an elite corps. And you acknowledge this and you put this in the comments. Well, she is, as qualified as this person, but we should choose her because of who she is. You've just given the government a handle to charge. And that's, and on the other hand, if you don't say that, if you don't acknowledge that, they'll say you ignored a red flag. So you really are caught in a catch-22.
I'd like to turn now to an interesting procedural case that the SEC brought against some executives, I believe, of Magyar Telekom, where I believe the executives were not U.S. citizens, not domiciled in the United States, yet the commission asserted jurisdiction to enforce the FCPA over them. If I have gotten that right, could you explain what you see as the significance of this case?
Well, the significance of this case up until this year was predicated on a rather expansive jurisdictional claim based on the use of emails. Magyar Telekom is an issuer and therefore it is subject to the SEC's jurisdiction with respect to books and records and internal controls. But for whatever reason, the SEC just wants to charge under the bribery provisions. And to charge under bribery provisions, they have to, against a non-U.S. company, they have to establish that that company, according to the statute, while in the territory of the United States, corruptly made use of the mails or any means of instrumentality of interstate commerce, or did any other act in furtherance of an offer, promise, payment and promise to pay. So how do they find, in this case, where these three individuals never stepped foot in the United States, never had a meeting in the United States, never placed a phone call to the United States even, how do they find territorial jurisdiction to charge under the bribery provisions? Well, what they did in Magyar in the pleadings was to allege that there was an email or several emails between someone in Hungary and someone in Macedonia or Montenegro. I can't remember which one because both were originally charged. And this email, according to the government, was sent using Yahoo Mail. And because all of Yahoo's servers are in the United States, that email must have passed for a fraction of a second, fraction of a millisecond, through a server in the United States. And therefore, that's the act in the United States that the SEC claimed gave them jurisdiction. It's an amazing theory. But nevertheless, Judge Sullivan accepted it, at least in the context of a motion to dismiss. And the theory he did so, and this he did several years ago. He did so on the grounds that this is jurisdiction, and it doesn't require a person to know that he stepped into the United States somehow. It's simply a question of whether he did. And he found that an email that passed through the server was sufficient, at least at the motion to dismiss stage, to establish to be a basis for jurisdiction. This year, it came around again. The case is still puttering along, and this time in a motion for a pretrial motion, he had to address whether there was sufficient allegations of a use of instrumentality under the statute. And this time again, there's the email argument, but this time there's another argument that the SEC offered, which I found to be strange. And that was that because this company is an issuer, the individuals, the executives in this case, could foresee that the company would be filing its periodic reports with the SEC using the internet. You file your reports on Edgar by submitting them through email through the internet, and that was an use of the instrumentality of interstate commerce. But to me, the problem there is the statute isn't phrased in that way. It says, while in the United States, make use of instrumentality in furtherance. So it's one thing if you go back to the original emails, by which has been, by which they've actually found very few that emails that actually pass through the United States at all. But that's one thing. If the email somehow furthered the scheme to pay a bribe, at least that's in furtherance. Here, you're talking about filing 10Ks or 20Fs or whatever after the fact that may include a false book and record, under the theory of, the consolidation of financial accounts. But how is that in furtherance of the bribe? That's what the government is obligated to prove, and I don't see how. And I've read the court's decision a number of times. I don't see how that works. How this use of the national exchanges or the filing of the internet over the internet somehow was in furtherance of the bribe. And the SEC isn't letting go of this. In the Teva case, although they didn't explicate how it applied, I noticed that they, again, in their jurisdictional provision in their complaint, again, refers to emails, refers to use of national exchanges, and refers to correspondent banking accounts. So they're hitting because as I read Teva, and I've read it a number of times, it's very hard to see how the activity, the conduct in Russia ever constituted something that was while in the territory of the United States.
So not only a new jurisdictional prong, but as I listened to you describe it, it almost sounded like that beyond even sending something through the internet, whether it be a 10K or Q, perhaps the knowledge that it could go through the internet might be the basis of jurisdiction at some point.
That seems to be Judge Sullivan's conclusion. That and he did acknowledge that it was a bit of a stretch, but he felt himself bound by an earlier non-FCPA case in the Second Circuit that does focus on foreseeability. Again, these are decisions at the district court. I believe, if this case ever does go to trial, if it ever gets to a verdict, this is a case that may very well go up to the Second Circuit, and maybe there'll be an opportunity to revisit some of these issues at the Court of Appeals.
Well, Philip, I'd now like to turn to the pilot program. And one of the, I think, key highlights from 2016 was the announcement and implementation of the pilot program. But I was wondering if you viewed it as a success, where you might see it going when it concludes after its first year in April, perhaps renewed, perhaps made permanent, perhaps changed in some format. But maybe start with how did you really view it in the context of 2016?
Well, I think it's a flawed program. And I don't like to sound so negative because actually I think the government often does a good job in these cases. And I understand the impetus behind the pilot program, which was to respond to people like me who said, well, what's in it for me if I come in and do a voluntary disclosure? What's in it for me if I do cooperation? And part of the pilot program was to say, okay, there is a benefit, and we're going to put a number on it. We're going to say if you cooperate, you get up to 25%. If you make a voluntary disclosure and cooperate, you can get up to 50%, which reflected to some degree just what was happening. I mean, this wasn't a sudden boon. If you looked at cases that have been done over, for years, if you made a voluntary disclosure, you got a discount. If you cooperated, you got a greater discount. If you didn't cooperate and you didn't make a voluntary disclosure, you got hammered, at least in most cases. So, to some extent, this reflected practice, but it put a little more structure around it so that, the companies would know, in theory, could know what they were getting into when they went in. But the problem for me with this program is the idea that people were advocating was that if you made a voluntary disclosure, under what circumstances would you get a declination? Would not where do you have to plead? Do you get a DP, a deferred prosecution? Do you get a non-prosecution? But when do you actually get the Holy Grail, which is a declination? And this sought to sort of explain that, but it did distinguish, and I understand as a former prosecutor, I understand why they did it, but it distinguishes between two types of declinations. One is a declination where there simply isn't any evidence, and that they shouldn't bring the case. And you would hope that that would be the case, that, in fact, you would question why you even make a voluntary disclosure, except to, stop the government later on if it comes to them, some allegation comes to their attention. But but the other type of declination is where the government exercises its prosecutorial discretion as it's entitled to under the principles of federal prosecution of business organizations, the so-called Holder/Phillip memo, and in that case, you make your voluntary disclosure, you cooperate, you do whatever the Yates memo requires you to do, and you want to look at them and say, well, okay, don't prosecute us. We've really done everything we can. We've got a compliance program. We've done this. We've got that. We've done that. Decline to prosecute. Exercise your discretion to decline to prosecute. And in that case, the pilot program sort of holds that out, the declination, but it's a declination that includes many of the aspects that you're trying to avoid in the first place. For instance, it's public. It says, despite you violating the law, we're going to decline. So they've now, not only is it public, they've now announced, not in the same amount of detail as a DPA, and not in the sense that you had to do an admission of facts like you would in a DPA. But nevertheless, the government has announced that you violated the law. And it's reported in that way. When we do our digest and when we count our stats, we count those declinations because the government said you violated the law. And third, you have to disgorge your profits. So, and disgorgement, you don't get any discounts because the government, and from the SEC or the DOJ, they cannot philosophically say you had an illicit profit, but we're only going to take half of it away from you. We're going to let you keep part of your illicit profits. They can't. It just doesn't. It doesn't scan well. So the 50% discount and all that doesn't apply to disgorgement. So no matter what, if you go in and you make it a voluntary disclosure and you cooperate and the government, does a pilot program declination, you still have to disgorge, everything that you gain through this. And either the DOJ is going to collect it in some way. It's not really clear what the legal mechanism is to collect it unless they go through a civil forfeiture procedure or something like that. But nevertheless, most companies will just write the check and go on. Or if you're an issuer, the declination is in the form of essentially a deferral to the SEC or a referral to the SEC. And you still may either get an SEC complaint or one of their alternative resolutions, the DPA, the NPA, which all, pretty much result in the same place. So it's not everything that it was, offered or that people had hoped for. And it could be that this is because of internal DOJ policies and disagreements about procedures or about approaches. And it could be that this will change in the next administration, or that the pilot program will be extended or made permanent, and perhaps include additional facts or additional factors, such as the compliance defense that was advocated by the Chamber of Commerce when Andrew Weissman was writing papers for the Chamber of Commerce, or similar things that Jay Clayton has advocated, through his chairmanship of a New York City Bar Association committee back in 2011. So I think the pilot program is likely to be continued. It may even lose the pilot part and become a permanent part of the fraud section policies, and it may be expanded in the next year.
Philip, I would like to end with something that I thought was also very significant from 2016, which were international enforcement efforts where there was a sharing of the fines and penalties. And I'd specifically point to Embraer and Odebrecht at the end of the year, and wondered if you saw in this any greater global anti-corruption enforcement beyond simply global cooperation on investigations.
I think there is something to be drawn out of these cases. I think earlier, a lot of these cases where there was sharing of the penalties or crediting of the foreign penalties, they were several of them, I think, were instances of piggybacking where the foreign prosecutors didn't really do much, but the company wanted quietus. It wanted some sense that it wasn't going to get hammered over and over again, and so it was willing to bring them in, and pay some part of the penalty to them and get a credit from the DOJ, and it was in its benefit, but there really wasn't any substantial amount of work being done by the foreign prosecutors. Siemens is an exception to that because the Siemens matter was actually initiated by the Munich prosecutor. And I think this year, these cases are less likely to be viewed as piggybacking cases. The Odebrecht and the Embraer cases, I mean, those were initiated by the Brazilian authorities. I mean, Odebrecht comes out of Lava Jato. Embraer, I think, is a long-running case. And these indicate to me that there is, in fits and starts, a growing effort among foreign prosecutors to bring their own cases. And if the U.S. isn't stepping down, and they help provide a framework for some of the settlements and for some of the calculation of sentencing. But some of these cases, I think, do indicate that the foreign prosecutors, the foreign governments, are bringing cases on their own against their own companies. There are certainly gaps. There's large numbers of the OECD countries that haven't brought substantial numbers of cases, if any, but there are some, and that's, I think, a helpful development, because the FCPA was not intended to be unilateral, and the OECD Convention was intended to create that level playing field, but the U.S. can't be the only one doing that. And when we are the only one doing it, that's what leads to what I think are some of the problematic jurisdictional theories, because the U.S. authorities are sort of taking the position that if you, foreign country X, won't bring a case against your companies, we'll find a way. And I understand why they do it, but it would be better for the statute and better for the the international community if it was more evenly spaced around the world, around the investigations, around the prosecuting countries.
Philip, unfortunately, we're nearly at the end of our time. I would say that I probably could have sat and visited with you for hours on this. It's been a great podcast, a lot of fun. We've been talking about the Sherman and Sterling 2017 FCPA Digest. I assume it's available on the firm website. I got an email notification of it, but it's available for download. It's a great resource. And once again, I would thank you and your team for putting it together for us all.
Oh, you're very welcome.
Hello again. This is Tom Fox. As you know, this was episode 299. So my next episode will be episode 300. On that, I have a special guest, Matt Ellis, who will talk about his new book, The FCPA in Latin America. I hope you will join me for episode 300 and a dive into Matt's new book. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate us. It would definitely help in our rankings with iTunes. This is Tom Fox. I'd like to thank you very much for listening to this episode of the FCPA Compliance Report.